Good afternoon, everyone, and welcome to the latest in our foundation series of webinars. My name is Stuart Pemble, one of the partners in the construction and engineering team here at Mills Reeve, and I'm joined by my colleagues Alex Pike, Alison Garrett, Lauren Michaelides and Martin Giaquinto. And we are going to be talking, if I can get the slides to work, pardon me, about the Building Safety Act 1 year on. Now, in fact, this is 6 months since we last did a webinar on the Building Safety Act. And during this webinar, we're going to be focusing on the developments during those 6 months. It's fair to say there's lots of ground to cover. So I'm pleased to say slides and perhaps more importantly, the recording will be available to everyone afterwards. The Building Safety Act is the most important statute that's been introduced, certainly in my legal career. And I don't think anyone needs reminding that it was introduced following the shocking Grenfell tragedy to improve safety in buildings, particularly in high-rise buildings. The building on the left is Grenfell before the fire. And we've included it to show you, to represent what most people probably thought high-rise buildings were. The two buildings on the right are actually buildings, both of which are caught by the Act in practice. On the top is a building 18 meters or 7 stories in height, and at the bottom is one 11 meters or 5 stories in height. The Act and the developments under it are incredibly fast moving. Only last week, Michael Gove warned the shareholders of Kingspan, Arconic and Saint-Gobain of what he described as severe consequences if those companies failed to help provide compensation. And Alison has some more hot off the press news later on in the webinar. The webinar with panel format, I'll be asking questions of each of the speakers. And if any of you have any questions, please raise them in the question and answer box. If we don't have time during the webinar to answer them, we'll deal with them later when we circulate the slides and the recording. So first up is a question for Alex. Alex, who is the Building Safety Regulator?
Thanks, Stuart. I think the short answer is probably someone we're all going to hear a lot more about. So the Building Safety Regulator will have 3 main functions. It will oversee the safety and standards of all buildings, lead the implementation of the new regulatory framework for high-rise buildings or high-risk buildings, and help and encourage the built environment industry and building control professionals to improve their competence, which sounds slightly ominous, I think, but that's how it's put on the Health and Safety Executive's website. The HSE says that it's preparing to carry out those functions, but in fact, the first of those functions started on the 1st of April 2023, and it has set up systems so that occupied higher risk buildings can be registered with the Building Safety Regulator. As well as that, the Building Safety Regulator will have the role of building control for higher risk buildings, so those over 18 metres or 7 stories in height, from the 1st of October 2023. So unlike at the moment, there'll be no choice of building control for those buildings. You'll have to use the Building Safety Regulator. And interestingly, works to a higher risk building are likely to be widely interpreted. So that might include converting a residential building back into an office, which you might think wouldn't be caught. So in terms of how the Building Safety Regulator fits in with the gateways we discussed in our last webinar, the consultation at planning stage, which is Gateway 1, is already in force. Building control approval, which I've just been talking about, will be Gateway 2, and as I said, coming in October 2023. Then there'll be ongoing requirements during the works. And the idea is that at completion, the regulator will have to issue a completion certificate, which will be Gateway 3, and is expected to come in April 2024. And as I mentioned briefly earlier, the regulator is also going to be involved in the regulation of the building control profession. So it's going to establish a register of building control inspectors and a register of building control approvers, which is expected to start up from April 24. And the government's actually pledging £42 million over 3 years to recruit and train 221 inspectors. So that sounds like it could be quite a big job.
Thanks, Alex. Let's turn to another new entity introduced by the Act, the accountable person. Alison, can you tell us briefly who is an accountable person?
Thanks, Stuart. I think the first thing to say about an accountable person is that it only applies to higher risk buildings, be they existing higher risk buildings or new builds.
Now, that's something Alex briefly mentioned as well. Can you remind us what is a higher risk building?
Yes, they're buildings that are 18 metres or 7 stories in height. So broadly speaking, the height of the buildings on the slide, on your slide of buildings on the top right-hand corner, with 2 or more residential units. And that's actually quite important because parts of the Act talk about dwellings, but here they talk about residential units. And it seems to me that a residential unit is wider than a dwelling and is likely to catch, for instance, student halls of residence. So to recap, high risk buildings, 18 metres, 7 stories in height with 2 or more residential units.
Okay, thanks. So who's an accountable person?
Section 72 of the Building Safety Act sets out who is an accountable person. Briefly, it's a person who holds a legal estate in possession, so a freeholder, of any of the common parts, and they're defined under the Act as well. There's some limited exceptions, but broadly speaking, a freeholder of any of the common parts, or a person who is under a relevant repairing obligation in relation to any common parts, so the stairwells, the corridors. There can be more than one accountable person per building, and we have more details from the government about what this actually means. The higher risk buildings bracket key building information, etc., close bracket England, close bracket regulations 2023 came into force on the 6th of April 2023, and they set out in more detail who the accountable person is. This is slightly tangential, but there's a lot of secondary legislation to the Building Safety Act, and a lot of it has these rather difficult to get your head round descriptions of regulations, and a lot of them sound very similar. So always make sure you're looking at the right regulations.
Yes, sounds like a barrel of laughs. You said there could be more than one accountable person. How are duties split where that is the case?
Well, there'll always be a principal accountable person, often described as a PAP, P-A-P. When there's one accountable person, they are the PAP. If there's more than one accountable person, then the PAP will be either the freehold owner or someone with a relevant repairing obligation in relation to the common parts of the structure and the exterior of the building.
Okay, so what are the duties of that accountable person?
They are numerous, and some are in force and some are to come into force relatively soon. Firstly, they must register the building with the building safety regulator, the regulator that Alex mentioned. That's for both existing and new builds. And in fact, registration for existing builds, in occupation builds, has already come into force. It came into force on the 6th of April. They've also got to acquire a completion certificate. This is not yet in force. This certificate comes from the building safety regulator. So it's additional to any practical completion certificate that you might normally seek. There needs to be a specific certificate from the building safety regulator. And in addition, they'll also need in due course to apply for what's called a building assessment certificate. Indeed, the regulator can ask the PAP to apply for one within 28 days of a building being occupied. And once you've got a building assessment certificate, you must display it within the building. It's likely this will come in fairly quickly, and it must include in the application for the certificate the most recent safety case report, information about mandatory occurrence reporting, a copy of any residence engagement strategy, and it must also demonstrate compliance with duties. So I think it would be sensible and prudent for anybody who thinks they are a PAP or an accountable person to be getting that information together now, ready for when it's required. The accountable persons also have to, perhaps unsurprisingly, assess and manage building safety risks regularly, keep certain building information, and there are two duties which are really about making sure everybody has the right information. One is that they must provide any relevant information to any new accountable person. And secondly, they must cooperate with any responsible person. Now, a responsible person has actually been in place since 2005. They relate to FAR and they apply to non-domestic premises primarily, but they also apply to the non-domestic parts of residential premises, so things such as the corridors and stairwells.
Thanks, Alison. Lauren, Alison mentioned the registering of the building. What is the registration regime and what does this mean?
Thanks, Stuart. The regulator will now be keeping a register of all higher risk buildings. So that means that all those higher risk buildings will need to be registered with the regulator initially. As Alison mentioned, a building is higher risk if it has 2 or more residential units and is at least either 18 metres or 7 stories high. The registration application can be done via the regulator's online portal, and it is that principal accountable person, the PAP, who is responsible for registering the building and submitting and maintaining all that other information required. Registration currently applies to all occupied high-risk buildings. The expectation is that all existing high-risk buildings will be registered before the 1st of October 2023, and failure to do so will constitute a criminal offence. From October 23 onwards, all new buildings must then be registered before being occupied. As well as just registering the building, the PAP will also need to submit quite a lot of information about the building itself, and they will also need to keep all of this information up to date with the regulator.
Okay, so what needs to be included in the application?
So for registration of the building itself, the PAP will need to firstly pay the registration fee, which is currently £251 per building. They'll also need the building's name, address and postcode, as well as some other information such as its height in metres, the number of floors and the number of residential units. They'll also need the year of completion for the building and also the names and contact details of the principal accountable person and also the accountable persons. As well as all of this, the Act also identifies key information that must also be provided to the regulator. This is set out in the high-risk buildings key building information regulations, those ones that Alison mentioned earlier with all those brackets. And in those regulations, it sets out the different details that are required, and that can include whether there is any building ancillary to the main building, and if that is itself high risk, whether there are any below ground stories, the number of staircases and how many of those staircases serve as part of the same flight of stairs, the primary and secondary uses of the building and of any ancillary building, outbuilding, or below ground story, details of the materials used in the external wall and whether there is any insulation in the external wall or main material, whether there is any insulation on any roof and whether the roof plane is pitched or flat, the main material used in the structure of the high-risk building and also the type of structural design. They'll also need details of the energy supply and storage system, and also the emergency planning information. That includes things like the type of evacuation strategy and the fire and smoke control equipment in the building and where that is all being kept. This key information must be submitted within 28 days of the registration application going in and must also be kept up to date. That is what the PAP is responsible for. They are responsible for providing all of this and notifying the regulator within 28 days of becoming aware of any changes to that info.
Goodness, that sounds like, well, an awful lot of information.
Absolutely. There is a huge amount there for the PAP to collect in and to also keep up to date. So it is really worth starting to bring this together as soon as possible to take the pressure off during that 28-day window you have initially when registering the building.
Thanks. So we've discussed qualifying leases in the previous webinar. However, how do these work where the landlord is going to pay for the remedial works? Lauren, could you quickly recap what the landlord certificate is?
Yes, absolutely. So taking a quick step back, a landlord will need to provide a landlord certificate to those leaseholders it would like to contribute to the remediation of any cladding and building safety risks. A certificate may also be needed if required by a leaseholder, if the leaseholder is selling its interest, or the landlord becomes aware of a defect not included in a previous certificate. The certificate itself must be in the form specified by the Building Safety Leaseholder Protection Regulations, and this will include details of the landlord's corporate structure, beneficial owners, and any other superior landlord. The certificate must then be accompanied by several other documents, including a set of company accounts, documents or receipts showing work that has been carried out in the last 30 years, and also any works carried out before that 30-year period. You'll also need to include details of any work undertaken since June 2017, and also the costs paid or to be paid for such work. As part of this, previous landlords can be required to provide current landlords with information, most likely in relation to those historic details and costings of works carried out at the building. So there really is quite a lot involved in the certificate.
There is. And so I suppose the question that follows from that is, what happens if a certificate isn't provided?
Now, failure to issue a landlord certificate will mean that the landlord has to pay for the works in full. And although it's not clear from the Act itself, the implication is that the certificate is not designed necessarily to be completed by a landlord who is actually intending to pay for the works in full. In those circumstances, a landlord might issue a confirmation of those intentions to the qualifying tenants so as to offer them some comfort that no contribution is going to be required from them.
Thanks. Now, Alex, this probably then brings us back onto the question of cost recovery by landlords in the context of qualifying leases. How's the position changed since our last webinar on the possible recovery of building safety costs by landlords from their tenants?
Yeah, thanks. So as you say, we talked last time about various hurdles that a landlord would have to get over to show it could recover money spent on building safety risk from its tenants. And there's been another one recently, which is Section 133 of the Building Safety Act. And that's an amendment to the Landlord and Tenant Act to place a new duty on landlords to take reasonable steps to use any other alternative route to recovery other than charging tenants for remedial works. So, for example, that might be by way of grants, recovery from third parties, or insurance. And if the leaseholders think the landlord's not taken those steps, that they can then make an application to the first tier tribunal to say that they shouldn't pay. So it's not clear just yet which buildings or types of works are going to be covered by this new right. But as it's been introduced as part of the Building Safety Act, you'd expect as a minimum it is going to cover the sort of works we're talking about here. There's been a consultation on this and what it should cover, and that closed on the 31st of March. So we are waiting to hear the outcome from that at the moment. But in terms of the sort of things the consultation considered, it was requiring landlords to make claims under insurance and to follow up any appeals process if that isn't successful, to look at home warranties, and pursuing third parties. And in terms of pursuing third parties, that can include seeking independent legal advice and pursuing the pre-action protocol. And moving on from that, the consultation sought views on what the landlords would need to provide to show they'd explored all alternative cost recovery avenues, and suggested or asked for opinions on updating leaseholders once a year as a minimum on what they are doing about those things. So there was a lot covered, but some indications of where it might be going. And given everything we talked about last time and all of that, it does make you wonder if recovery from tenants is ever really going to be cost effective.
Thanks, Alex. It's fair to say that things just seem to be getting more and more complicated. Martino, what complications might have reached the courts?
Well, thank you, Stuart. So pleasing to say that there have been some, and we've got 3 listed on the slides. So I'm going to touch upon those, 2 from the courts and 1 from the first tier tribunal, the FTT. 2 cases are Building Safety Act cases and the other isn't, but it does concern cladding and fire safety defects. So the first we're going to touch upon is the Batish and Inspired Sutton case. The relevance of this decision is that it's the first that addresses the new right or remedy available to leaseholders under the Act concerning remediation contribution orders. Now, some cautions required when drawing or attempting to draw any conclusions from this decision, because none of the parties were represented, legally represented, and the first respondent, the first defendant, was actually debarred from taking part in the final part of the proceedings because it didn't comply with procedural orders. Nonetheless, the decision does demonstrate the scope of the new jurisdiction to make the remediation contribution orders. Now, by way of recap, Section 123 of the Act permits leaseholders to obtain a remediation order, and this allows the FTT to order a landlord who's required under a lease to repair or maintain to remedy those defects in a building if those defects are causing a building safety risk. And Section 124 creates a right to ask for a remediation contribution order. And this enables the tribunal to make an order requiring the company or partnership to make a payment to meet the costs incurred or to be incurred in rectifying those defects that creates the building safety risk. Now, both these remedies seek to respond to building safety risks and they're backwards looking and only apply to defects from works that have already been undertaken, but they could go back 30 years, so have some real potential application. Now, these remedies are interesting, I think, for two reasons. First, for ordinarily in law, for a person to come under any liability to remedy something or to pay money, they would normally need to be in breach of a duty imposed upon them. However, under the Act, there's no mention of any need to prove any breach under either of those sections. Instead, the tribunal can make a remediation contribution order simply on the ground that it is, inverted commas, just and equitable to do so, close inverted commas. So that's the interesting thing. What does that mean? What's the ambit of that? What are the factors that deal with that? And this case touches upon that. The second interesting thing about the case is the ambit of the potential parties that could be in the crossfires of an order, because it's not only the landlord or the developer, but it can be persons associated with either of those two. And as lawyers would say, by virtue of this provision, the corporate veil can be pierced to allow parties that wouldn't otherwise have a responsibility for these defects to be footing the bill. So that's the preamble, the facts. Leaseholders in a high-rise block of flats were required to make significant financial contributions to the costs of rectifying various works within the building carried out by the landlord. Those costs had already been incurred by the landlord, and the leaseholders had been required to contribute to those costs by virtue of their service charges. As you might expect, the leaseholders were unhappy about that, so they made an application to the tribunal for a remediation contribution order to compensate them, to reimburse them the £200,000 that had to be contributed to make good these defects. And the leaseholders made the application not only against the landlord, but the landlord's parent, who was insolvent, and for good measure, two of the directors of the landlord. So what about the decision? Well, unsurprisingly, the claims against the two directors were dismissed. The tribunal noted that a remediation contribution order is an order requiring a specified body, corporate or partnership to make payments. As neither director fell within that definition, the application was dismissed. But the tribunal decided to make a remediation contribution order against the landlord because the building was a qualifying building. It was a relevant building. It was structurally detached and at least 5 stories in height. The lessees were interested persons holding legal interests in the properties, and the landlord developer was a relevant specified body corporate. So the tribunal held that the costs did relate to relevant defects, and in particular that the defects constituted a building safety risk. It's quite a broad definition in relation to that. Now, it's really only 7 or 8 paragraphs of the decision that deals with the reasoning. Central is paragraph 48 and 49. At paragraph 48, the tribunal said, we can only make a remediation contribution order if we consider it just and equitable to do so. So that is correct. And then they said, to satisfy this test, we need to be sure that the lessees have paid for the costs of the works, which ought to have been met by the landlord. The tribunal decided that no service charges are payable for defects which are the responsibility of the landlord, and ordered that the landlord ought to have picked up those costs and was liable. The tribunal said that there were, inverted commas, no mitigations or other matters to be taken into account in the exercise of its discretion. So the leaseholders were entitled to a full contribution, but that was the extent of the reasoning given by the tribunal as to what's within or out with its discretion. So it seemed quite wide in that sense, but then narrow because the tribunal related it to costs incurred, whereas the actual provision doesn't limit it to costs incurred. It does relate it to a liability for future costs that may not have been spent. So, and as I say, the interesting point is that provision could have greater impact, because if and to the extent that historic service charges have been paid by leaseholders to cover such defects, now under the Act, they could bring an application, an order for a remediation contribution order going back till 1992. So that's the first. The second, as quickly as I can, is the URS case, BWD. Now that's in the Court of Appeal at the moment, and I understand that day one started yesterday. Why is this interesting? Well, it's interesting because it all concerns limitation, and it concerns the extended limitation period within the Act. Now, the facts are a little complicated, but in short, BWD was the developer and had engaged a structural engineer in relation to structural calculations between 2005 and 2012. It then later transpired that there were issues with the design. The developer then brought court proceedings against the structural engineers, and they had to put their case in tort because any contractual claim was out of time, and they were proceeding on the basis that damage accrued at a later date, so after practical completion. They didn't plead and couldn't plead a Defective Premises Act argument. And this was a residential development with occupiers in the apartments, and the developer wanted to recover the full cost, which was millions, in relation to the rectification works. The structural engineers ran various arguments, predominantly limitation arguments, duty of care, that kind of thing. A decision was made in the TCC, first instance decision, and broadly speaking, the consultants lost on those legal points. Those were decisions of preliminary issue. The consultants then sought permission to appeal. During that time, the Building Safety Act came into play, and the developers thought, hang on, we've got the benefits of an extended limitation period under the Defective Premises Act. So the developers then sought to amend their case to bring in a new claim, and the Defective Premises Act doesn't need to have the contract or tort restrictions. It's anybody who does any work associated with this. So the developer wanted to bring that into play. The Court of Appeal, a single judge, dealt with some matters on its face, and you could see the importance of this. What the judge said is that he acknowledged that the developer could seek amendments to its case, and the relevance of this is under the Act, the Building Safety Act, in relation to these extensions of time. It does have a provision which says the courts should strike out claims, newly in time claims. If they were to go ahead, they would be an infringement of somebody's human rights, fair trial. But it also says those claims cannot be reopened if the matter has been settled by agreement or finally determined by a court. And of course, one party said, you cannot do that. Those decisions have been finally determined by the court. You cannot bring in this retrospective Defective Premises Act. The Court of Appeal, single judge, said the Section 135 is novel and the issues to which it gives rise have never been considered before. Because of the pragmatic approach he adopted, the first instance judge, they were not considered in detail. Depending on the precise issues which arise on these appeals, some appellant guidance is helpful. And therefore, the Court of Appeal are going to deal with this and address this issue about the retrospective effect of that and whether a party can take advantage, notwithstanding the provisions in the Act. Running over time, the final case is the LDC George Downing case. This isn't a Building Safety Act case, but it is a cladding defects case. I think the key issue here is in relation to the issue that the subcontractor raised. Employer brought a claim against the main contractor, design and build main contractor. That claim was settled. Both parties then had proceedings against the subcontractor. The subcontractor provided design and build obligations under a DOM 2 subcontract, domestic DOM 2, and relied upon a provision concerning reasonable skill and care in its design. And the issue was whether the statutory requirements imposed a mandatory obligation to meet the design, or whether the reasonable skill and care obligation somehow watered it down or trumped it. The court emphatically said no, on a proper construction, the subcontractor was subject to the strict obligation to comply with building regulations, and provision in relation to reasonable skill and care of their design did not trump that. And reference was made to the Supreme Court decision in MT Hogarth and Eon. And the second point was that the court took the view that an argument was raised as to betterment. And the subcontractor said, well, now all of these remedial works have been done. They've been done to a higher standard because they need to now comply with the new regime, which is unfair to us. And the court said, no, all of that is recoverable. If remedial works are undertaken to a more up-to-date standard, which might be criticised as betterment, then the costs of those remedial works are still recoverable against the ultimate culprit. So there you have, Stuart, a quick run through, and one can see, I think, the direction of travel in relation to recovery for legitimate losses.
Yeah, thanks, Martin. So the key point here is that the courts are going to robustly enforce building safety generally and Building Safety Act specifically, and their arguments about why the Act shouldn't apply in a particular case are probably going to be given relatively short shrift. Moving away from case law, Alison, could you tell us about self-remediation contracts, please?
Well, yes, you may recall, Stuart, the Building Safety Pledge, where the government asked certain developers and house builders to pledge to remediate life-critical fire safety works. in buildings over 11 metres in height, where the developers or house builders, have played a role in developing or refurbishing those buildings within the last 30 years.
I do remember it because you told me about it, Alison.
Well, self-remediation contracts are not actually called that, but they're being generally referred to as that, are formal contracts between the Department for Levelling Up and the relevant developer or house builder. These are major residential property developers, that they will do a number of things. The first of which is an obligation to identify and assess buildings requiring works.
And what does that mean exactly?
Broadly, it means where there is a life-critical fire safety risk in a residential or a mixed-use building over 11 metres in height, where there is one or more residential common hold or leasehold property under a lease with a term exceeding 21 years, or the building is owned by a registered provider of social housing in England, and where the developer or the house builder or one of its group companies, so here again we're seeing some piercing of the corporate rail, were involved in the development or refurbishment, but not purely as a contractor, in the 30 years prior to the 5th of April 2022. So we're going back as far as April 1992. I was looking at what was happening around that time to give us all a flavour, and I'm old enough to remember that, but apparently Right Said Fred with Deeply Dippy was in the charts at that time, and that does seem very long ago.
Okay.
To help this process, they often need help from what is known as the responsible entity.
Who's that, or they?
They are the freeholder or the superior leaseholder, or they could be a management company.
So if you are one of those and you receive requests for information in relation to fire, you shouldn't be surprised.
Exactly, and indeed we've had anecdotal evidence of this happening. The requests are likely to be they will be for up-to-date fire safety assessments or a fire risk appraisal of the external walls. And if you are a responsible entity, you may be able, if it's going to cost you some money to get this information, you may be able to seek reimbursement of some or all of your costs.
And is there anything else that they have to do?
Well, once they've established buildings requiring works, they're under an obligation to carry out and complete the works, the developers stroke house builders, at their own costs. There are some exceptions, but that's broadly what they're obliged to do. And they're obliged to keep the responsible entity and the Department for Levelling Up informed of what's going on. And lastly, and perhaps quite importantly as well, they have agreed to repay the Building Safety Fund in respect to these buildings. So if these buildings had already sought and obtained funds from the Building Safety Fund that the government set up for remedial works to rectify cladding and other building safety risks, then these developers stroke house builders have said they will repay those funds to the government.
Okay, so pretty onerous. I suppose the obvious question is, why would anyone choose to sign up to this contract?
Well, apart perhaps from a desire to rectify the wrongs of the past, the government has used something called the Responsible Actors Scheme, which I know doesn't sound very construction orientated. And indeed, in the last day or so, it's issued the Building Safety Responsible Actors Scheme and Prohibitions Regulations 2023.
That's the hot off the press thing I mentioned earlier.
That's hot off the press, yes. Effectively, it means that if you're asked to sign up to a self-remediation contract and you do not do so, there are complex procedures for a responsible actors scheme to come into force. But what it actually means for you is that you will not be able to undertake schemes involved in providing for 10 or more residential units, residential schemes on sites of more than half an acre, commercial developments where floor space is more than 1,000 square meters, developments on a site of any description of more than 1 hectare, waste development, and winning and working of minerals. So you're going to be frozen out of the market. Yeah. And perhaps not surprisingly, or perhaps a bit surprisingly, the explanatory notes to these draft regulations that came out yesterday have made it clear that the scheme will in due course be extended to other developers and house builders, not just the major ones.
But it's just the major ones who've signed up to the pledge, is that right?
It's the major ones who've signed up to the self-remediation contracts at the moment, bar one or two that the government have asked them to sign, have actually approached them and asked them to sign up. And it's anticipated that they will be doing that. They will be approaching people and asking them to sign up to it.
Wow. So moving on to perhaps something slightly more mundane, but probably practically important, fire doors. What can you tell us about fire doors, Alison?
Well, it's a bit wider than just fire doors, but the Fire Safety England regulations came into force on the 23rd of January of this year. And you may remember that at the beginning of this webinar, I talked about the responsible person and how you need a responsible person for the non-domestic parts of residential buildings, i.e. the common parts. And these regulations relate to the duties of the responsible person, who has actually, as I said, been in place since 2005. What's interesting about these regulations is that some of the provisions have no height requirement on them at all. Some have 11 metres and some have 18 metres. So where there is no height requirement and you have a building which has 2 or more domestic premises and common parts through which residents would need to evacuate, the responsible person must provide specific fire safety instructions in a conspicuous part of the building and information about fire doors. In addition, if the building is over 11 metres or 5 stories in height, the responsible person must use their best endeavours to check fire doors at the entrance of each individual domestic premises at least every 12 months and to keep a record of where they can't gain access. And in communal areas, they must check the fire doors every 3 months. And for higher risk buildings, these are buildings that I talked about earlier on, 18 metres or 7 stories in height with 2 or more residential units, the responsible person must now install and maintain a secure information box. And that box has to have quite a lot of detailed information contained within it. They must prepare a record of the design and materials of the external walls. They must prepare a plan for each floor, including lifts, and a building plan which requires quite detailed specific information to be included. And all those plans have to also be incorporated in or added to the secure information box. They also have to undertake monthly checks of lifts and other firefighting equipment and ensure clear wayfinding signage. And we've had anecdotal evidence of the fire service actually now undertaking, as you would expect, checks to ensure this is being done.
And so these are big boxes, not small boxes.
Yeah.
But
yes.
Fantastic. So, Alison, finally, second staircases. What is all this about?
Well, this is very interesting. The government issued a consultation which actually closed on the 17th of March as to whether all new residential builds over 30 metres in height, so we have yet another different height requirement here, should be required to have a second staircase. In fact, there had been some large high residential buildings in London where this had been an ongoing issue even before the consultation. As I said, the consultation closed in March, but before that, in February, Sadiq Khan, the Mayor of London, actually ordered that all new residential buildings in London over 30 metres in height should, with immediate effect, be constructed with second staircases. And that has, perhaps unsurprisingly again, caused some design and disruption and delay, confusion with regard to high-rise residential or buildings, i.e. over 30 metres in London. As I said, the consultation nationwide closed on the 17th of March. So at the moment, we've got this bizarre position where we've got a second staircase required if you're building in London over 30 metres in height, but nothing for the rest of the country. It's anticipated, however, that second staircases for the whole of the country will come into force probably in October. The question, though, is whether it will be a height limit of 30 metres or whether it might be lower, because the RIBA, the Royal Institute of British Architects, as well as other environmental bodies, when they were responding to the consultation, suggested that in fact the height requirement should be 18 metres in height, not 30 metres in height. I think if you are building a building residential building over 30 metres at the moment, you would be prudent to be designing for a second staircase, wherever that might be in England. But you may have to rethink, and it may turn out to be as low as 18 metres. It also leaves another question, and that is, what do we do with existing buildings that are high, that are tall, that don't have second staircases? We could, if nothing is done about them, will we face the same problems we've seen with regard to cladding? Will they become difficult if they're in the private sector to sell or remortgage? The RIBA, in their response to the consultation, suggested that those buildings should be refurbished with evacuation lifts. So we'll have to wait and see if the government follows up on that as well.
Goodness, so I think what you're saying there is that, and I suppose it's inevitable when any requirement as blanket as this comes in, is that it's not just going to have an effect on buildings that are currently being built or are to be built in the future, but it can have an effect on buildings that are up and running at the moment. And of course, it can have an effect on their valuation, for example.
It can have an effect on
the value of the building.
Yes, I think that's right. I think that's what we saw right at the beginning after Grenfell with cladding, and we potentially are going to see the same thing with staircases.
Well, thanks very much to everyone. I'm just looking at the questions. I think Sarah, to answer your question, I think a 30-meter building is about 10 stories. That's just Google being your friend. Graham's asked, should all the information that's currently being asked for, shouldn't that already be available in the FRA? That's an acronym, I must admit, I'm not sure I know the meaning of. Oh, the fire risk assessment, sorry, yeah. I think the answer is no, it shouldn't, because or whether it should be is it isn't, and the statutory regime being introduced by the Building Safety Act is changing that. Alison, I don't know if you have any thoughts on that.
Only to say that I think that's why it's been introduced, because it wasn't necessarily always included in the fire risk assessment. And I can't comment particularly on Grenfell, but I suspect that there were high-rise blocks of flats where it wasn't available automatically, and the government is making sure that there are going to be no loopholes in it.
We've also discussed as a team that there's plenty of anecdotal evidence that when certainly high-rise buildings were being built, quite often some of the fire safety requirements were never actually installed, and that one of the things that the new regime has highlighted is and particularly you were saying with the fire service doing spot checks, is that existing buildings that may not have dangerous cladding do still have other fire safety defects that need to be corrected.
Yes, I think that's most certainly the case. In my life as a construction disputes lawyer prior to Grenfell, nearly every defect claim had included in it in some shape or form lack of fire compartmentation or something similar. And it was just almost not quite a shrug of your shoulders, but yes, well, what do you expect? It's never done properly. And I suppose it's catching up with the construction, really, the shortcuts that perhaps were taken in the past.
Fantastic. Well, thank you very much. I'd like to thank all of the speakers, Alex, Alison, Lauren, and Martino. At the end of the webinar, there will be a feedback form, and I'd like to ask everyone who's logged on if they could complete that form. I also, there are links on the screen to our construction and engineering blog, practicalcompletion.co.uk, and to our LinkedIn group, where we highlight various things, including those blogs on practical completion. I think just I'd like to, oh, there's a couple more questions.
I've just seen one, Stuart, about what is a PAP, which is an easy one for me to answer. Principal accountable person.
Yes, and if you remember, Sarah, there was Alice explained that there can be more than one accountable person. If there's one accountable person, that accountable person is the principal accountable person. And if there are more than one, then there has to be one principal accountable person has more responsibilities on them.
There's also another one which Claire has raised. I think I'll just read it quickly, Claire. It's about this 28-day period to provide key information, and Lauren and I have had a long discussion about this already. The legislation says that you have 28 days after you register your in-occupation building in order to provide the key building information. But Claire is right, the government's website and guidance has suggested recently that actually you've got longer, you've got until the 30th of September 2023. The position is really confused at the moment, and our conclusion was that it would be wise to do it within 28 days because there's been no change to the legislation as such, but the government's own website is suggesting you've got longer than the 28 days. I wouldn't take the risk. I don't know if there's anything you want to add to that, Lauren.
No, I don't. It's a little confusing, and as you say, Alison and I have had a big discussion about it, and it's just a little confusing that the Act and the guidance that has recently come out on the government website seems to differ.
But Lauren, can I just to confirm on that point, the strict legal answer is it's the Act that sets out the time that the Act applies. If the government's given misleading guidance that doesn't represent what the Act says, then that's unhelpful and misleading from the government. But it doesn't amend the Act.
No, focus on that 28 days.
Alison, there is a question from Sarah about what the Act says about the EW1S form. And I'm not sure it says that much about them, does it? Because that's that's the form that the RICS had introduced in order to help deal with, well, as a problem, Sarah asked the question, people being able to get confirmation that the building in which they live is safe and mortgageable.
Exactly. If you get an EW1S form, the idea is you're able to persuade a purchaser or somebody a bank or building society that they should either buy or lend money to you because your building doesn't have fire safety defects, or if it does, they have been rectified. I don't think the Act itself says much about those as such. I think it's more looking at buildings that need rectifying still. So I think my understanding of what I've read in the press is the EW1S system, so far as it can, is working as well as it can for those that have been able to get confirmation that their buildings don't have fire or cladding defects.
The problem was there weren't enough surveyors willing to sign the form or with the requisite professional indemnity insurance.
That's been a big issue, and the government was trying to sort that out with the insurance industry, or I saw commentary suggesting they were trying to sort it out. I haven't heard anything to the effect that they haven't managed to, but the whole EW1S system, as far as I can tell, is working more smoothly than it was.
Fantastic. Well, again, thanks everyone for signing in, and thanks again to Alex, to Alison, to Lauren, and to Martino. And I'd like to wish everyone all the best for the rest of the day, and if it's not too early to say so, a happy bank holiday weekend when it comes.